following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the legal framework surrounding caveats and last wills in Sri Lanka. How has the law sought to protect property owners from lapses in caveat regulation? And is the legislature relating to last wills adequately updated? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we break down key legal concepts for the layman. Tonight's topic is something I'm sure every one of us has heard at some point, be it in media or be it in their personal spheres, because it's something that pertains a lot of information, and that is on caveats and on last wills. Now, we've heard these terms, we've heard last wills, we've heard assets being left to people in their wills, but how exactly are they governed? What's the legislature behind such last wills? These documents, they are to govern how this distribution is happening after someone has left this world. So how exactly does the law strive to protect our individuals when it comes to the distribution of these assets? And also caveats, how exactly does that relate to property owners, and what exactly are the implications of caveats, and how has it changed over the years? So to speak about these two very intricate topics, we have someone I believe is the best suited individual for this discussion as well, and is not a new face on the show, and that is attorney at law Nirodha Kalansooriya. Thank you very much, ma'am, for taking the time to speak to us today. It's a very packed topic, so I'm sure we're in safe hands when it comes to this discussion as well. Well, a little brief introduction on Ms. Kalansooriya. She has 21 years of experience in this field, and Ms. Kalansooriya is also a senior lecturer at the Sri Lanka Law College, a lecturer at Kuthalawala Defence University, and I'm sure with last time's discussion you can remember that she's also the convener of the Law Reforms Committee for Conveyancing Laws at the Ministry of Justice, appointed by the Honourable Minister of Justice. Well, before we get into the discussion at hand, here is a small breakdown of how we're going to approach this topic. So first we'll be talking about caveats, because that is a little bit of a heavier aspect of this discussion, especially with the new amendments that have been coming in. Next we'll talk about last wills and how that is governed in the law, and if there have been reforms coming in. And finally we'll be talking about the future with amendments and reforms.
My name is Shaila and I'm a fashion student. My question is on caveats. What are caveats and how do they affect property law?
All right, well, without any further ado, let's get right into this discussion. We have quite a lot to break down as well, ma'am. Well, I'm sure that not everybody is completely knowledgeable when it comes to the legal aspects of a caveat or a caveat, some people might say. Please, could you explain to our viewers, ma'am, what exactly is a caveat?
Thank you for inviting me, Anuradhi, for the show. And when it comes to caveats, that is set out in the Registration of Documents Ordinance, Section 32. So caveat is actually the meaning, the term is that caveat emptor. It says that it is a Latin term which says that buyers should be aware. So if we take this concept simply, the caveat is that it is an encumbrance of a property. So if somebody wants, any intended purchaser wants to purchase a property, this has to be cleared. If a notary, when checking the title of a property, so he or she should not recommend this property as a security or to purchase, because it is an encumbrance. So that has to be cleared before purchasing. And Anuradhi, we have seen that mostly it has become a habit of filing caveats for the properties these days, in order to, because they do that, the people, they are doing it in order to protect their rights, because they think that filing a caveat, they are protected. So how it happens is that when you file a caveat, the land registry will notify that person when fraudulent transaction, an instrument, when fraud is happening. So you will get a notification, you will be notified that something is happening to your land. So that is why people are filing this caveat. It is an encumbrance as well as it is a protection for your property.
So it's a double-edged sword, so to speak. Well, now that we spoke about exactly what a caveat is, could you please explain to us who exactly is allowed or who can file a caveat on a property?
Yeah, this was actually a lacuna in the law, Anuradhi, because the Act was not, it has not been specified who can file a caveat. It says any person can file a caveat. But this has been amended recently. The definition is given. To be more accurate, I will quote the same section in the Registration of Documents Ordinance. It says the caveat can be filed a person who has a right, title or interest. So that person should have an interest to the land and claims to have a right, title or interest. So that says any person cannot file a caveat. So that person should have an interest to the land. So definition is given, the lacuna is cured in the law. Because what has been happening, Anuradhi, when any person could file a caveat, so now we know that people, they sell their lands. So in order to sell a land, what happens is now they should give a copy of the deed to a third party. So that can be the purchaser or the broker. So then when there is a dispute between the seller and the intended purchaser or the broker, so they start they filed caveats, they lodged caveats to those properties. Then what happened was the seller couldn't even sell it to another person, couldn't even mortgage it to a financial institution or a bank. So he was stuck with that. So therefore, so in order to avoid this, now the person is defined, so interested party. So then it goes on to say, the Act says, the amendment actually says, who is this caveator? So Act says the caveator is a body of persons, a beneficiary under a trust, or lawful guardian or next friend of a minor, a person or unsound person, or an attorney by a power of attorney. And also it says the interest, it defines the interest, what kind of an interest you should have to the property. It says an interest arising from registered or unregistered deed. But we know that it is now, the amendment says that deeds has to be registered. It has become compulsory. But even previously there can be deeds which are not registered. So unregistered deeds relating to land and registration of a trust or inheritance or by sales agreement or by mortgage, that interest, using that interest, they can file a caveat, which means even banks as a mortgagee, they can file caveats to the properties. So that is what is, who the person is defined, where the lacuna is cleared and the interest is also defined.
So now it's not just anyone that can, there has to be a specific interest in the property as well. Especially I'm sure our audience might have had personal experiences where the broker has been involved and there's an encumbrance to the land. I'm sure there's a lot of disputes going on about that as well. So this amendment seeks to clear that out in order to give more agency towards the actual interested parties. Right. Well, now I think we should move on to the technical aspects as well. Now, filing a caveat. What exactly are the requirements in order to file a caveat? What are the documents that we need to put in order to put into effect a caveat?
That was also another issue, Anuradhi, because earlier what has happened was just the caveat could have been filed. So we don't know whether that party has an interest or who is that person. Even under fraudulent names, anonymous names, they lodged caveats. So now, Act specifically says, actually the amendment in 2022, it specifically says person who is going to file a caveat, he or she has to submit it in duplicates. So there will be 2 copies. And one you can get from the land registry after registration of the caveat. And also it says it has to be in duplicate and accompanied by an affidavit from the caveator saying that I have an interest to the land. He should, swear that. In addition to that, a certificate has to be issued by a notary saying that that particular person has an interest to the property. So there will be 3 main documents. One is the caveat in duplicate. Second one, an affidavit from the person, caveator, and a certificate from an attorney at law. So then we are mostly covered. I mean, the frauds can be eliminated. I mean, frauds of course cannot be eliminated. We can mitigate that. So to a certain extent, we can safeguard the person. So then you will get a copy from after registration of 1 copy. So that part is covered. And also you have to furnish the full name of the caveator and self-addressed envelopes, witnesses' details, and all that will have to be submitted. So then mostly it is covered.
Do you believe that it is mostly airtight now with the new documents that are being required and the new processes being followed by the amendment?
Mostly covered, Anuradha. As I told, frauds cannot be eliminated, but all the ways and means that frauds can happen and frauds had been happening has been, to a certain extent, yes, covered.
Great. So there is a bit of a bottleneck. I guess our viewers can rest assured with the new amendment as well. Well, now imagine we have a caveat that we don't want. How do we cancel it, ma'am? Because that, I believe, once it's in place, it's a bit of a headache to try and figure out the process. It's a very intricate process as well in how to remove such fetters and clogs from the land.
Anuradhi, if somebody wants to cancel, the period of a caveat is anyway 2 years. Maximum period is 2 years. If somebody wants to extend it, mostly people who are going abroad, they want to have the caveat, renewed for every 2 years because they prefer doing that. So you can renew it. But the maximum period is 2 years, and for that is for 2,500 rupees, very reasonable amount. So you can file a caveat. But if you want to remove it, and if you want to sell it or mortgage to remove it, you can file a cancellation of caveat. Right? You can send it together with the original caveat. If you could give it, you can get it cancelled. But what happens is, Anuradhi, sometimes the caveat, now when there is a caveat, so you will get a notification. So say somebody has filed some fraudulent transaction or deed or anything to the property. So then you will get notified from the land registry that this is there. Then within 60 days, you have to take action. Earlier it was 30 days, but in order to give ample time for the people, so it has been extended for 60 days, basically 2 months. So you can go to courts, district court, where the land is situated, and you can institute an action in order to set aside the caveat. So if the court satisfies that that is a fraudulent transaction, the court will set aside the caveat. And there can be instances where to your property somebody else had filed a caveat, say due to some error or something, so caveat is filed already. So then how to remove that caveat, because that is your property. So then again you can go to the courts and institute an action, get it set aside, and also you can ask for damages. So that is also there. And also if the court decides that caveat is unnecessary, it is not according to the law, unlawful, that particular person cannot file another caveat to the same land. So Registrar of Lands should make sure that that is not happening. Otherwise then he will keep on registering caveats. So that is also provided by the amendment.
Right, so the amendment has set out to straighten some of the certain loopholes as well that might have been employed by certain malicious entities in order to put a fetter on certain properties. But ma'am, a little question of curiosity as well. Now, we know exactly how the cancellation of a caveat will go. What exactly are the repercussions of having filed a caveat? Now, we spoke about what a caveat does, but how exactly, are there completely adverse repercussions to filing a caveat, or could it possibly be doing more harm than good?
Of course, no, Anuradha. It is better to file a caveat to your property, but the harm is that for any action there can be a harmful adverse impact, no? So that can be, when you go to a financial institution, they will ask you to remove the caveat and cancel it and come. And so those are the things that when you are in abroad and if you want to get it cancelled soon, then you will have to appoint a power of attorney holder, and then you will have to get it cancelled because it's not a clear property. It is with an encumbrance. So nobody will purchase, nobody will touch that property because there is a caveat. So that is the only harm which I can see. Other than that, it is a protection for your property. It is good that if you can file the caveat.
So now would you believe that with the amendments it is more encouraged in order to approach caveats as a means of protection rather than a nuisance, one would say?
Exactly. It is a protection, Anuradhi, because actually the cancellation was before introducing the amendments. The cancellation, some people they fraud the signature of the caveat on cancelling. So those were also happening, but now the original caveat has to be presented with the cancellation. As much as possible, all the loopholes have been cured. So I don't think you can get any fraudulent thing done through a caveat filing now. So I think this is not aware. People are not aware by this particular precaution. So some people through media and all that, they get to know, and then they come and ask us, so why can't we file a caveat? So otherwise, Anuradhi, if they are aware of it, most people, if it is not mortgaged to a financial institution or a bank, it is advisable to have a caveat on your property.
Right, but there's a lot of negative discussion around it as well, because that's all we have usually heard, especially in our social spheres when it comes to, oh no, there's a caveat on this land. Looks like there's going to be a lot of a big process, so people put off even having to purchase it or wanting to pass it down even. Well, ma'am, a question of curiosity here. Now, there are multiple documents that are necessary in order to file a caveat, in order to rescind, in order to actually free from the fetters as well. What actually happens if some of these documents are misplaced?
You mean the caveat?
Yes.
Yeah. So when registering the caveat, all these documents were looked at by the land registrar. Before registering the caveat, that is his responsibility, his or her responsibility. And he's supposed to register the caveat on the extract, in the sense you will have to write it down and then return one copy to the client. So that is also his responsibility. So it's the responsibility of the client to give the proper addresses and the envelopes and all that. So other than that, it's a responsibility of the registrar. So there is a possibility of misplacing it at the land registry because of the lot of documents they have and all that. But you will be getting a copy. You have a copy. So therefore, if you have a copy and if it is registered, you can prove that. So that caveat is registered. As you said, Anuradhi, it's a lot of talks are going around. Caveat filing is not, not good because if it is filed by a third party, if you file a property to your land by yourself, that you are safeguarding your right.
Right, yes. It is essentially something that prevents people from usurping whatever that you have legally entitled to your estate. Well, we have a lot more to discuss. I believe the chapter on caveats was adequately explained. Thank you very much, ma'am, for that. Before we go into last wills and the requirements surrounding that, let's go in for a short commercial break. You're watching Law and Liberty. Stay with us.
Hi, I'm Sahasra and I'm an undergraduate. My question is on the last wills. What are the means of passing down assets and how are valid last wills formed?
Welcome back to Law, Land and Liberty. We are in discussion with Attorney at Law Nirodha Kalansooriya. Ma'am, we just embarked on a very momentous topic as well, caveats. It's a very intricate discussion, but thankfully we had you to break it down for our viewers to make it much more digestible. Now that we have passed on that topic, I think we should get to something that I'm sure a lot of us are interested in, and that is last wills. Last wills and testaments is something that we've all heard about in some way, shape or form, be it in mass media or even in our personal spheres. If somebody has passed on and has left something in the will, could you please explain to us now, how are these assets passed down originally? Are there multiple ways? How exactly is that process approached?
Yes. And succession in Sri Lanka is twofold. Either you can leave a last will, that is called testate succession, or else you leave without a last will, the person is deceased, then it is intestate succession. So it is twofold. Last will is something you write before the death, expecting the property will be devolved, these legal heirs which you have nominated, and it will be devolved in that way. So that is the difference between the testate and the intestate succession.
I see. So it's only just two ways. It's very binary. Those are the only two ways by which it can pass on after posthumously.
Yes.
All right. Well, then I think we should get into the legal aspects as well when it comes to the creation of a last will. How exactly? What is the legislature or the key legal requirements surrounding the creation of a valid last will?
Yes. If I elaborate on without having a last will before, is it all right, Anuradha?
Of course, please. Yeah. I feel like our viewers would very much appreciate that.
So, inheritance is a right of a person, as Van der Linden, the popular law related the researcher, says that this intestate is a right, inheritance is a right, but that right devolves to the legal heirs upon one's death, and then those people can, exercise that right. And that right, the person has to be deceased without a last will, or else last will should be null and void due to some reasons. That is how the intestate succession comes into play. So in Sri Lanka, the intestate succession, which is without a last will succession, is governed by Matrimonial Rights and Inheritance Ordinance number 15 of 1876. It says upon one's death, that property should go to descendants first. Descendants means your children, grandchildren, and remote descendants. If failing which, it goes to the ascendants, Anuradhi, which means that deceased person's mother and father. If that also fails, it goes to the collaterals, that means the sisters and brothers. So that is that is governed by the Matrimonial Rights and Inheritance Ordinance. For an example, if we say, if some person dies, leaving his wife, half goes to just children, half goes to the wife. If he doesn't have children, issueless, so that half goes to the parents. So wife gets the half and the half goes to the parents, mother and father. If mother is alive and father is not alive, then 1/4 goes to the collaterals, sisters and brothers. That is how it happens. If the child is an illegitimate child, generally mother's inheritance comes and the father's rights, father's properties, he can't be entitled. And also it says that if there is a loophole, and we know that if there is a loophole in English law, the English law there will apply. Same way, if there is a loophole in the ordinance, Roman Dutch law applies, which is prevailed in North Holland, is the law. But at the time of enactment of this statute, South Holland and the North Holland law is not uniform. So it is not tally with the same law. So that is also there. But according to the law, this North Holland, the prevailing law has to be adopted, is what it says. So that is what inheritance. So we'll come back to your question, the last will. So people used to write last wills, execute last will, because when they, in the good old days, Anuradhi, when they went for pilgrimages, forces, so they used to write a last will because they had an impression that he will not be able to come back. So therefore, people used to execute last wills, and there were two ways to execute a last will: in front of a notary or with 5 witnesses. So you don't need to have a notary, but it has been amended recently. Now there has to be a notary. Now you can't execute last wills with the 5 witnesses. You have to have a notary. We will discuss later. That is because the fraudulent things that are happening. So last will can be executed in front of a notary. So as you asked, the last will, the formation of last wills is basically it can be done by a competent person, and that has to be done according to the laws. Complying with the laws, it has to be executed. So that is how the last will has to be executed.
Right, so there is a very specific process now as per which we should go by in order to create a valid last will. But ma'am, just picking on what you mentioned earlier before my question, of course, where you mentioned without a last will, the distribution of assets, is that law completely clear at the moment? As you mentioned now, there's a very specific set of requirements that has to be fulfilled in order to for certain interested parties to get their certain shares. Has that changed over the years, or is it the same as what you mentioned with the
It is the same, Anuradhi. So when there is no last will, it governs by the according to the matrimonial rights and inheritance ordinance. So then people will have to go to these courts according to where the land is situated, where the person is deceased, according to that, and file a testamentary action, and then the court decides who should get what, and according to the law that will be devolved to the legal heirs. So that is the court finalizes that, and then the administrator's conveyance is executed. The administrator who will be administrating the property. He will be administering the property, and he will thereafter give it to legal heirs. If it has to be executed, the conveyances will be executed. So thereafter it will be devolved to the heirs. So that is finalized. That is called the court procedure. For last wills also you have to go to a court, because some people says when there is a last will, he is the owner of the property. That is not correct. So it only gives an administrating power. I mean, one person will be appointed as an executor. He will have to go to courts, and he will have to prove the last will. Then only these people will be entitled. But only difference is, Anuradhi, when there is no last will, according to inheritance, it will be devolved. So spouse, children, God. But if you have a last will, you can nominate anybody. You can, even the amendment says, you can exclude your children. You can exclude your wife. You can give it to a third party, whom you wishes. So that is the advantage of or the disadvantage of the last will. So if somebody is helping that person, caretaker or somebody is there, so the person might write the entire properties to that person, excluding all his family members. So that is also possible.
So we've heard stories relating to that as well very recently, also in mass media, especially. Just harping on that specific issue, ma'am, there is no way, especially for grieving parties, maybe it is your father or your husband, and they have left it to a third party. It's not something that has been illegally done. It is definitely possible for them to completely exclude everyone that has blood ties or even has marital ties to you.
Exactly. That is given in the enactment. Even the amendment says, so you can give it to exclude those parties. But only thing is, Anuradhi, it has to be genuinely executed. There can be fraudulent, by undue influence also there. We'll be discussing that. So if that is so, then you can, challenge the last will. Otherwise, the person who is executing the last will has that right.
So now you mentioned the executor's conveyance as well, ma'am. That is something that's now since we're specifically talking about last wills and we're not talking about administrative conveyance under inheritance, let's speak a little bit about that specific area when it comes to the appointment of an executor. Could you please explain to us if there are any restrictions, if there are certain guidelines that has to be met in order to be a valid individual for this?
Yeah. So last will has to be, Anuradhi, has to have the legal heirs appointed. In order to be a valid last will, it should be complied with the laws, and the person should be competent to write a last will, execute a last will. When I say competent, it has to have, that person should be above 18 years old. The lunatics and the insane people, deaf and dumb, and minors, all of them are excluded because they are disqualified. They cannot write a last will. So competent person should be able to write a last will, and it has to be complied with the laws in Sri Lanka. And also a legal heir has to be appointed. Right? So when you appoint legal heirs, right, you can have severals. You can have if you want, you can have your wife and your mistresses, and everybody can be there. But you have to nominate. Nomination has to be there. And also the Grotius says in their books, he says even born unborn, people who are not born, you can have the last wills, you can have the inheritance. And if there is a miscorrection, misspelled in the name, if the identification can be done, you can take that name. If the surname, by surname, if you can identify the person, the legal heir, yes, you can have that person to take the person as the heir of a will.
So does that mean that everything on a will is contestable?
No, it is not. The presumption is that the will is genuine if it is executed. But somebody can challenge it, and third party can challenge it, saying that it is executed using undue influence and all that. But then the person who is going to challenge should prove that. The burden of proof lies on the person who is challenging it.
Right.
Otherwise, the presumption is that it is valid, it is genuine.
Of course. I mean, that is, if there is any sort of challenge, it has to be proven in court and there has to be valid reasons for it to be so. Ma'am, you just mentioned something about people not qualifying in being able to form their own last wills, people that are incapacitated, people that are not mentally sane. What happens to these individuals if they are to want to leave a last will? What exactly is the process there?
Of course, they are not, they cannot, even in law of contract, Anuradhi, you can't get into a contract. I mean, these disqualified people are unable to enter into a contract. So they, of course, they are disqualified. But then what happens is they comes under the normal raw matrimonial inheritance rights and inheritance ordinance. So that law applies, which means that there is no last will. When the person is deceased, you have to go to courts, and if he has properties, so that can be institute an action and the properties can be devolved accordingly. So, but these people can be nominated in the last wills to get their shares, that is fine. But these people cannot execute a will.
Right.
But they can inherit properties. Another person can make that person as an heir of a will. Yeah.
Right. So technically, even though they're unable to actually form a last will of their own, they are able to be part of a last will of someone else's. Well, that is a very curious question as well. We have a lot more to discuss when it comes to wills as well, but unfortunately time has come against us in this segment. We'll definitely pick back the discussion when it comes to the validity of wills as well. Before we do any of that, let's go in for a short commercial break. You're watching Lawland and Liberty. Stay with us.
My name is Nirodha and I am a student. My question is on the future of last wills. Does the current legislation need further amendments?
Welcome back to Lawland and Liberty. We are in our final segment with attorney at law Nirodha Kalansooriya. We were talking about caveats and last wills. And I'm sure that was an interesting segment that we just passed on, because a lot of us would have heard about last wills, but we don't really know exactly how assets are passed down and how things are bequeathed to any heirs or people that surround a person posthumously. Well, ma'am, a question of curiosity that I wasn't able to touch on before we went into the break. Now, you mentioned about being incapacitated and being unable to form a last will, a valid last will. Before we go into the validity aspects, I feel like this question is a little bit of a question of curiosity. When it comes to posthumously deciding whether a will was valid or not, what if some individual challenges that this person that formed the last will was not in their right mind or was not in the state or capacity to make a last will? What happens then?
Anuradhi, now it has to be executed in front of a lawyer, a notary. Right. So notary should see whether that person had the capacity to execute a last will or not. So the notary is also liable if he executes a last will from a disqualified person. So this happens where sometimes children comes and say, my mother is ill and she is in hospital, and can you go and execute the last will when he is in the hospital? So the notary should ensure that that person is having sound mind. If he or she is not sure, the notary is not sure, better to have the medical reports and all that, bed head tickets and all that, and to see whether that person has sound mind. Because now, according to the amendments, notary should write in the attestation, certify that person has the sound mind, he is in good mind, sound mind to execute the last will. So that becomes the notary's responsibility as well, if that person is capable. So when the notary is there, so and if she executed, if it is a notarially executed last will, it is considered as a valid last will, because under the new amendments, so he or she, the person cannot execute a last will with 5 witnesses. So it is a responsibility of the notary as well, Anuradhi.
Right. So if a notary has decidedly shown that, okay, I approve this document, it has been done by someone with a sound mind, then there can be no contest regarding the validity of that will as well. So specifically considering posthumous documents, when my mother was not in a sane mind when she did this specific last will, I think we should talk about the validity aspect as well, because now we just came into it. When it comes to fraud, of course, a lot of people would have heard about these, especially when it comes to influential families. There's a lot of infighting going on relating to the bequeathing of assets, because that at the end of the day, once that person has left the estate to certain individuals, there are different conflicts of interest. So could you explain to us, ma'am, how is fraud in this specific area? It's a very sensitive topic as well. How is it approached in the law?
Yeah. So as I told you, Anuradhi, the last will, presumption is that it is genuine if it is executed properly. So presumption is that, especially if it is executed by a notary, it is a notarially executed document, presumes that it is a genuine document. So undue influence is the issue that which can challenge the last will at any given time. But then that party has to prove that it is because of these reasons I am challenging it. The burden of proof lies with them. And the last wills also, Anuradhi, one can make several last wills. Once I do a last will today, I can revoke it and do another last will tomorrow. So you can keep on executing last wills. So if you wish us, so today my son is good with me, so I write all the properties to him, the next day you can change. So that right is there. But only thing is, after marriage, if he does another second marriage, so then that the last will which you have written is executed is void. And by tearing it off, by burning it and all that, you can destroy that. So there was a case where it is a decided one. Legal heirs, they went to courts and said that there was a last will, but they couldn't find the last will. So then what has happened? Then the court decided he must have destroyed it because it's not there, and the property was devolved according to the matrimonial rights and inheritance ordinance, according to the general law in the country. So the last will not has been taken into consideration. So therefore the last will be written in duplicate. There will be 2 copies. One is with the lawyer and the other one it will be sealed and envelope, it will be given to the client. It is a confidential document. You don't have to register it in the land registry. Last wills are not registering. It is not a deed. It is a confidential document. So the original will be given to the client and the lawyer has the other one. So then once the person is deceased, so you can talk to the lawyer, and we don't have the original. So if you have the original, you can go to courts and you can institute action through a lawyer.
So while the last will is not declared to a land registry per se by the client, when it comes to the lawyer and declaring their monthly lists of deeds and whatever transactions or notarizations that they have done, they have to declare that such a document is in their possession.
The recent amendment said you have to have the number and all the details in your the deed register. Everything has to be declared in your deed register. That is also confidential. But to the land register, the monthly list, you don't have to put all the details.
Right.
So who is the executor and all that. It is just a last will and your number. The parties' names and all that you won't have to mention because it is a confidential document. And Anuradhi, by last wills, that way also you can, as you asked, can make frauds. But of course, the final one will be the valid one, because you can keep on executing last wills. So the final one is considered as the last will which he made. And you can amend last wills also through codicils. So if you want to do changes, so you don't have to write a last will again. That is called codicils. Section 6, if I remember correct, says same authority is given to codicils as well as a last will. But only thing is you can't appoint a legal heir by executing a codicil.
So a completely new will has to be formed in order to declare a new heir.
Exactly.
But adding on to certain different distribution of assets can happen through an amendment.
Can do.
Right. So it's not a completely convoluted discussion, but one thing that I just understood from this discussion, ma'am, is that last wills are easily perishable, is it?
Yeah, so yeah, that is, Anuradhi, it is there. And even if you, that even though it is a confidential document, it is also there. And Anuradhi, there's one more thing which we couldn't discuss, that is about the foreign last wills. So there can, because during the COVID pandemic, the properties are here in Sri Lanka. Sri Lankans were in abroad. So they wanted to write a last will. So then that can be done. Execution of last wills outside the Sri Lanka is possible, but then they will have to go to courts and get the probate when the person is deceased, and it can be submitted to Sri Lankan courts and resealed and get it executed. Then the properties can be devolved to the legal heirs according. So that is also possible. And there was a case which discusses whether properties are in abroad, the movable property, that is for the immovable properties, lands and all that. So this is a foreigner basically. Properties are there, but he is living in Sri Lanka. Whether the last will can be done. So that is prohibited. That cannot be done. But people who are outside the Sri Lanka and the properties are immovable properties are in Sri Lanka, yes, you can do a last will. But then you will have to go to courts there in that country, get the probate, and you have to submit it to Sri Lankan courts and get it resealed.
Right. So when it comes to the opposite, where the properties are not in the country, but the individual that wants to write the will is in the country, it's not possible. Would that be due to the fact that it cannot be covered under Sri Lankan law, or is that it's covered under the law of?
That is movable properties, cannot be covered under.
Right, right. So if it is formed under the law of that specific country, would that be a possibility?
Yeah, if the property is there and if it is, the last will is done according to that particular country, that would be. But in Sri Lankan law, and even if the other way, Anuradhi, properties are in Sri Lanka and the last will has to be executed according to the laws of that country. Formation of last will. Because those days there were a lot of queries, how they should do the last will according to the Sri Lankan law or the laws that related to that country. So that should be according to the laws of that particular country, and that had to be proved in that country, and the probate has to be sent to here.
Right, because the entirety of the estate is in that country, so therefore in that jurisdiction. Well, ma'am, speaking about now, we spoke about fraud as well, and we understand that there is a little bit of it's a very tight line to walk as well when it comes to the validity of a will. But what if there is some sort of honest misgiving when it comes to the formation of a will? What are other protections that have been provided to any heirs that have been mentioned when it comes to leaving a will?
Yeah. So, Anuradhi, whenever last will is considered as a void, it was challenged and proved that it is void, always goes back to the normal inheritance. So if that person has excluded the legal heirs, the family members, and appointed some other person, then that is gone if the will gets voided. Otherwise, if any at given time, if it is void, we have to go back to the normal inheritance, and the court will decide accordingly. And also, Anuradhi, there can be instances where now from the recent amendments that has been offered to the clients, that is that you can have a joint last will. Because husband and wife both can have a joint last will. In that way, if husband dies before leaving spouse, leaving the wife, then for husband's share, it can be proved, and you can go to courts and proved and get. The properties can be devolved. When the wife is also deceased, then again you can go to courts and accordingly that can be done, proved. So what happens is, if a common property is owned by husband and wife, the husband's wish is to give it to someone else, and after his death, you can't change his wish. You can't change that the way that he expected. But for your share, you can do the changes by executing a codicil or whatever.
So
that is
if
also there.
by any chance the entirety of the land is in question and it has been given different interests, then there will be no changes made.
No.
Right.
His share he has already given and he is deceased. So after his demise, you can't do the changes to his wish, his share, only for his shares. But the wife's surviving spouse's share, you can do the changes.
Right, ma'am. Do you believe that with the passing of time, we've seen amendments being brought in, the legislature surrounding last wills and the inheritance has slowly started to become more and more clear over the years. Do you believe that there is more room for improvement when it comes to this legislature aspect?
It's like this, Anuradhi. The reforms are done according to the problems that have been arisen and all the issues that brought in by the clients and all that, and we have faced. So with that experience, amendments have been done. But there can be instances where the fraudulent things might happen. So we will have to see whether that scenario and take precautions. But for the moment, I think we have covered almost all the areas, and it is now watertight, and there cannot be, because when it comes to last wills, Anuradhi, you have to paste the person who is executing that person's photograph, and you have to have the signature and the fingerprint as well. So there is no room to do the fraudulent transaction so far, because when you place the fingerprint, it is a quite serious issue. So people, I don't think they will tend to do frauds when you asked to place the fingerprint. So we'll see.
Cautiously optimistic for the
Exactly.
future. Well, unfortunately, that's all the time we have when it comes to discussing last wills and caveats. I believe this is a very loaded discussion as well when it comes to the information that we just learned. Thank you very much, Attorney at Law Nirodha Kalansooriya. Thank you so much for taking the time to speak to our audience.
Thank you for inviting me, Anuradhi.
All right. Well, the complicated nature of owning and bequeathing assets have always caused some strife among even the closest social groups. However, it is essential that we understand that the law exists to demystify these very intricacies when direly needed. Exercising our agency includes following due process. We leave you tonight with the words of Ambrose Bierce, an American journalist and Civil War veteran. Death is not the end. There remains litigation over the estate. That is all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube channel, youtube.com/otherderana English. Thank you for watching. Have a great night.